It's Friday afternoon. We've locked the door because we did so many drugs we can't feel our face, and we love it. Shout out to the weekend. And also because it's time for another edition of our weekly podcast, Tales from the Brown Desk. I'm Jake Rigney of Rigney Law LLC. With me as usual is my law partner, wife, and the Karen of my dreams, Kassi Rigney. Terry Ulm is our host, manager, topic selector, floor demand monitor, and email screener. Friendly reminder, Tales from the Brown Desk is a free-flowing conversation involving two foul-mouthed attorneys. It may include graphic descriptions of sexual activity, violence, and dusty old case law. It may not be suitable for children, Supreme Court justices, Amy Coney Barrett, Brett Kavanaugh, or Merrick Garland. Listener discretion is advised. Here's Terry.
Hello, everyone. Hi, Jake. How are you today?
I am pretty good. I had a delicious cheeseburger for lunch, so I'm 3 days closer to death, but I feel good about myself.
Nice. Hi, Kassi. How are you?
Very good. Hi, Terry.
So last week we talked about some recent Indiana Court of Appeals opinions and the defund the police movement. And this week we're going to talk about stacking charges and about a very important Indiana Supreme Court opinion that changed the controlling law in Indiana when it comes to double jeopardy. But before we begin, I want to talk a little bit about Operation Legend.
I know that this is the one where John Legend and Chrissy Teigen dropped off a bunch of stuff in the Gulf, right? For the people that got hit by the hurricanes.
No, this is a little bit more widespread.
Oh, okay.
Yes. So Operation Legend is a federal law enforcement operation that is taking place across the United States. According to the White House, Operation Legend was implemented after Trump began deploying federal law enforcement agents to crack down on crime in the wake of the George Floyd protests.
Right.
Agents from various federal agencies were deployed to aid and assist city and county law enforcement officers. And in August of this year, the operation was expanded to include Indianapolis, Indiana.
To assist them, right?
Yes.
Even
yes.
if they didn't ask for assistance.
Right. They're here. The operation was announced as a collaboration between local police and federal agents to tackle gun violence, drug trafficking, and gang activity.
Mm-hmm.
U.S. Attorney for the Southern District of Indiana, Josh Minkler.
Yeah, you got it. Oh,
There's your song.
Kassi, they're playing our song. Police sirens.
Now, U.S. Attorney for the Southern District of Indiana, Josh Minkler, told the Indy Star that there were 57 federal agents dedicated to Operation Legend in Indianapolis.
Mm-hmm.
They have recovered 49 firearms from the streets of Indianapolis. They've arrested 18 fugitives, and over 20 individuals have been federally charged. Minkler said the operation has been so successful that on October 1st, he reported to the Indy Star that the operation is extended indefinitely.
We decided to do our job for a little while, and it's going so well, we're going to keep doing it. Who knew?
Now, however, Keith Wildstyle Paschal, a West Side music producer and photographer, called Operation Legend a propaganda campaign to make the public feel like somebody's doing something about public safety. He said the issues that need to be addressed are poverty, and that is what is going to solve and help the gun violence and crime in Indiana.
Yeah. This brings me to a sentence that I always hoped I would get to say.
Yeah.
Which is that Keith Wildstyle from the West Side is right, and Josh Minkler, the attorney for the U.S. Southern District, is wrong. Thank goodness we have someone like Wildstyle out there to set Josh Minkler straight. And I'm not being sarcastic. I think Wildstyle is right.
Yeah, I was a boots on the ground deputy prosecutor in the war on drugs for 8.5 years. This is a bigger stick, swifter stick. It doesn't solve the problem long term. It looks good, makes scared people feel safe. It does solve an immediate problem. I mean, I'm not going to say there's no value to it. I mean, they are sweeping up people with histories, and they're going after people that are doing things that obviously they could charge, but that's not a long-term solution. It's poverty, it's education, it's healthcare, it's employment. Those things are what need to be addressed.
It amazes me that people with a very high stake in how this community turns out and with very high level degrees still haven't been able to figure this simple truth out, right? Which is that if you do not give people something to live for, they will not care about what happens to them in their lives, right? They will not make self-interested decisions to not break the law. So you pack them together in poverty, you create systems that makes it extremely difficult for them to get out, including funding their schools poorly, over-policing their neighborhoods, and you make them feel like they don't have any opportunity for advancement, and they will not make decisions based on concern about going to prison. They just won't do it. It doesn't matter. Prison is not much worse than where they live. And so it's just amazing how they think that what we need is more punishment. What we need are bigger sticks. What we need is send people to prison for longer, enhanced enforcement. The people who are breaking the law don't care about enhanced enforcement. It doesn't deter them. Deterrence only happens when you have something to worry about not having anymore. And if you don't have those things, you will not be deterred from committing crime just because the law or the government says they're going to punish you, or because they say they're going to punish you harder. It doesn't work like that.
Right. I agree completely.
Right. Doing what they're doing is like taking a hungry person and giving them a big stack of $100 bills and saying, "Here you go," but all you can do is eat it. They can eat a $100 bill, and it may provide some nutritional value in the short term, but it doesn't really help them in the long term. You have to help these communities. You have to figure out ways to improve their schools, to show them a way out of the financial situation that they're in, instead of making it harder, instead of making it worse, instead of creating schools that are nearly Ponzi schemes where executives make a bunch of money. You make them for-profit schools, and then they don't teach them anything, and they're stuck right back where they started. And that's what you have to fix in order to do this. Enhanced enforcement is it's like telling them to eat a $100 bill. It won't help long term.
No, it won't. So now we're going to talk a little bit about stacking charges, or charge stacking. Does this phrase mean anything to you, and which one is right?
I hear charge stacking, but I would assume they mean the same thing. Two different ways to say the same thing. It's just really a prosecutor taking a factual or evidentiary situation and brainstorming to charge it every which way they can think of. And that may be like how you see OWIs, for example. You'll have multiple OWI counts. Oftentimes we'll see, the C misdemeanor operating with no endangerment, the A misdemeanor operating plus endangerment. You'll have if you have a chemical test with a certain range, you would charge the OWI with the BAC in that certain range. And it's just, they get 3 shots at trying to make their case, if they ended up in trial.
And that's before we talk about metabolites.
Now, some say that prosecutors will stack charges against a defendant, building a very long potential prison sentence if convicted, and then approaching the defendant with a plea deal that would result in a guaranteed but reduced charge and sentence if the defendant agrees. Is this standard practice for prosecutors?
I know when I charge as a prosecutor, if I was going to trial, we're going on everything. So, but also, it's kind of misleading, because that seems to indicate to me that someone thinks that you just take a sentence and add them one on top, one after the other, and that indicates to me they don't understand how it works, because you don't actually get sentenced for multiple times for the same act.
Actually, it's a very good example of sort of when lay people look at charges, they don't see what lawyers see, right? Because if I see a case where a guy's charged with 5 or 6 things, and Chad wants to know, what he's really looking at in terms of sentence, one of the first things I do is I start trying to figure out which one of them are double jeopardy barred, right? Because they can't, even though they can charge you with however many things they want to charge you with, they can't always convict you of all those things. And people don't understand that a lot of times, especially lay people who don't have any training with it, although it is an extremely complicated area of criminal defense work, and not all attorneys understand it either. But yeah, usually it's much more complicated than just figuring out what the range for each sentence is and adding them together, because a lot of them are going to be barred by constitutional considerations.
Now, can prosecutors add charges once a criminal case has been filed, or are they stuck with the charges they initially filed?
After what's called the omnibus date, they can still try to amend. Potentially, you can amend up until you rest, or at least until the trial commences. The thing is due process, and due process is only notice and opportunity. So a lot of people like to think, oh, well, you got this omnibus date. Well, you missed that date. That's a magic line. Like I always think of what the Dukes of Hazzard. There's that magic line. If you can just beat that line, you got it. Everything's good beyond that. That's not really how that works. So they could potentially file amended charges on the morning of trial, and if the defense had notice of that occurrence before, that would be okay.
Now, a couple months ago, the Indiana Supreme Court published an opinion, Wadle versus the state of Indiana. And this opinion changed the controlling law in Indiana when it comes to double jeopardy. Now, we touched a little bit on double jeopardy in past episodes. Can you explain to the listeners what double jeopardy is?
Yeah, well, I can try. Like I said, it's become a very complicated area of the law, but the Indiana and U.S. constitutions say that a person cannot be put in jeopardy twice for the same offense. Interesting, it doesn't say 3 or 4 times. So maybe if we just tried it 3 or 4 times instead of twice. No, that's a joke, a really bad lawyer joke. Which means that originally what it meant was that if you were charged with a crime and you were convicted of it or acquitted of it, they couldn't charge you again and punish you again for it. So that's what it meant originally. But once this practice of filing 5 or 6 different charges for the same event started happening more, which is largely a 20th century occurrence. This didn't happen really in the 18th and 19th centuries, but in the 20th century, we started making a lot more things illegal, and as a result, the prosecutors had a lot more power to charge a bunch of different theories on the same thing. And eventually, the U.S. Supreme Court said, well, look, we're going to start applying double jeopardy to this so that you can't convict a guy for stealing. It sort of gotten to the point where if somebody had stolen $1,000, the state could charge them with 1,000 counts of theft for stealing $1.
That's ridiculous.
I mean, I'm not saying that's what happened. I don't know of a case where, but it's like that, right? Where it's gotten to the point where they can pile a bunch of different things on and then try to get stacked sentences out of it. And because of that, the Supreme Court eventually applied double jeopardy to that practice as well, so that if you are convicted of multiple offenses in the same course of conduct, then they will look at them to determine whether double jeopardy bars conviction on those things. And that's what happened in Wadle's case.
Now, can you give the listeners a little background on Wadle's case and explain what has happened in this opinion?
So I can give you some background, okay? But I'm going to be honest with you about this, all right, Terry? You assigned us was it 42-page opinion?
37.
37-page appellate opinion that completely rewrote an entire area of a subset of criminal defense work. So I got to about page 8.
It doesn't currently apply to any of the cases I'm working on, so it wasn't particularly interesting.
Right. Now, I mean that is no disrespect to the Indiana Supreme Court, because everything they write is very important, and it all matters to someone, if not lots of people. But I'm busy too, Terry. Busy. Very busy. So I skimmed through parts of it yesterday, and I made it through about 8 pages this morning before one of the many things that I had going on interrupted me over and over again. Mainly you two with questions about one thing or another, including setting up our new Sonos speakers and everything else. So basically, with that disclaimer, here's what I remember about what happened in Wadle, okay? Jordan Wadle was out drinking at a bar in Connersville, Indiana. Shout out to Connersville, Indiana, by the way. Many of my cousins live there or near there. My parents graduated from high school there.
Do they know Wadle?
I don't know. I didn't text them all to ask, but it's, in the words of Everclear, it's a small town. So probably. Most likely one of my cousins knows him. Anyway, he went out drinking at a bar. The bar isn't identified, which is a shame because I bet my dad's been there. But, and he hit on a girl while he was there. This is according to the Supreme Court opinion. Mr. Wadle may have different opinions about what happened that night, but he hit on a girl, and it turned out she was married, and her husband and her husband's brother did not appreciate his advances, and they had a discussion with him out in the parking lot about it. Now, when I say discussion, I'm not using that as a euphemism for trying to beat him up or beat him up. It just means they said some shitty things to him out in the parking lot about it. Wadle apparently responded by taking a swing at the brother, so the brother-in-law of the girl he was hitting on, and kicking him too, apparently. And then everyone kind of decided the fight was over, and the alleged victim, I should just call him victim at this point, whose name was Woodward, he's the brother, turned to walk away when Wadle went to his car, jumped in, and ran him over in the parking lot. Then he let Woodward get up and ran him over again, slamming, like pinning him up against a guardrail or something like that. Woodward is probably lucky to have survived. He was in the hospital for a long time, had a fractured skull, among other injuries. And then Woodward left, which turns out to be the most serious crime he got convicted of, the leaving.
Not the almost killing a guy?
No. I mean, he got convicted of some of that too, but he was charged with aggravated battery.
I was just going to say he didn't get convicted of the battery.
Right. Here's the thing. He was charged with aggravated battery, which is a level 3 felony. He was also charged with leaving the scene of an accident where he was intoxicated and it caused serious bodily injury. That's a level 3 felony. Aggravated battery is also a level 3 felony. And then he was also charged with a series of other DUI counts. DUI causing, or OWI causing SBI, OWI with a prior. He went to trial, and the jury found him not guilty of aggravated battery. It's peculiar that the jury found him not guilty of aggravated battery. We'll never know why, although it's clear from the opinion that Justice Goff didn't really seem to agree with it. He went out of his way kind of to describe the situation in a way that was very pro-state and pro-Woodward. He even he wrote it almost like a novel, like left his victim there broken as he left the scene. Like he took specific time to sort of paint a very flowery picture of what must have been a very ugly scene that night in that parking lot in Connersville. But for reasons nobody knows, the jury found the defendant not guilty of aggravated battery. They did find him guilty of leaving the scene of an accident while operating while intoxicated, causing serious bodily injury.
But didn't the serious bodily injury, isn't that the battery?
Yes, but with the battery, in fact, batteries, the aggravated battery statute's a little different than serious bodily injury, but it is entirely possible, and this is one way to reconcile it. The jury decided he didn't hit him with the car on purpose.
Twice.
Or knowingly.
And this is where it comes in, because generally on the SBI, on the OWI count, the knowing act there was the driving. And in the battery, the knowing act would commit what made the injury. So this is where, until you're really in a jury's seat, looking at instructions and looking at what your elements are of each charge and what really has to be proven, that you don't get a clear picture of how this all works.
Yeah, and it brings up another point that most people don't understand when they see appeals opinions, right? So when a criminal case is appealed in Indiana from a conviction, the Court of Appeals assumes that the evidence presented that supported the conviction is true. So Justice Goff's explanation about what happened that night, when he explains it in his facts, may not be correct. But because of the way appeals work in Indiana, the law requires him to assume that the facts that supported the conviction are what happened. It's possible that what happened in the trial is that Wadle testified and said, I hit him and I was scared and I took off, but I didn't do it on purpose. And he may have denied several of those other things. And the jury may have decided that was reasonable doubt, and they weren't going to find him guilty of aggravated battery, but he was definitely driving drunk and hit a guy, hurt him, and left the scene, and so he's guilty of that other level 3 felony. That might be what happened. That's a reasonable explanation for how he got found not guilty of aggravated battery. But I don't know, because I wasn't at the trial. Justice Goff will assume the facts that support the conviction are true, even if the jury didn't accept all of them as true. It doesn't matter at that point. So Wadle left the scene, went to trial. He got convicted of all the driving stuff, but not the aggravated battery. And then the trial court sentenced him. They entered judgment of conviction on all the counts and sentenced him. The Court of Appeals said, yeah, you can't enter judgment of conviction on all these counts. And they cited a well-known Indiana Supreme Court opinion called Richardson versus State. I almost called it Robertson versus State because I had a case go to the Indiana Supreme Court that I tried called Robertson v. State, and it was a sentencing issue too, but not as cool. Anyhow, so Richardson. Richardson is a very complicated case, and I don't have time to go into all of what Richardson says, but basically it says we have a two-part test for how to determine whether two different counts are the same. And in Wadle, the Indiana Supreme Court overruled Richardson. They said that's not the law anymore. It's created too many problems. Justice Goff weirdly took a moment out to thank the people who wrote it and to tell them, that, sort of give them that it's okay. You tried hard.
While also saying it wasn't anything you did. It was basically all the times the Court of Appeals messed it up. Yeah, there is this paragraph that, it was funny.
Now, can you define what same offense means for our listeners?
No, and especially not now, because I haven't finished reading Wadle. But the old, and this is why it's so complicated, the old standard had an either or, right? It was the same offense if all the elements of one offense were included in another offense, or all the facts you used to prove one offense were also used to prove the other offense.
All facts? Can you use some facts? One fact?
Well, all the facts that proved one also proved the other. I'll try to give you a simple example, although, like I said, this is a very complicated issue. So, for example, burglary is a level 4 felony if you break into a house, and it's a level 5 felony if you just break into some building. Okay?
A house because there's people there?
Yeah, it's a house.
It's a home.
People care more.
Private.
So it's a little bit higher level offense, right? So if you were arrested for burglary, the state could charge you with both crimes. But if you were convicted of both crimes, the judge could not enter judgment of conviction on the level 5 felony, because all the elements of the level 5 felony are also in the level 4 felony, right? So it could only punish you once for doing the same thing that they charged 2 different ways, okay? That's the lesser included test. The other one is the actual evidence test. The example for that is, say, I shoot and kill someone, and I get charged with murder, but also aggravated battery, right? I mean, I did cause a substantial risk of death to the guy, you can tell, because he died.
Yeah.
In that case, the elements of the offenses are different. So it is not one is not a lesser included of the other in terms of what the elements are. But the state would use the same facts to prove both, which is that I pointed a gun at a dude and shot him, right?
Mm-hmm.
So in that case, if I was convicted of both of those offenses, I could only be sentenced on one of them, and the double jeopardy clause would prohibit the court from entering judgment of conviction against me on the second one.
And I'm assuming this is like those deals you go to a store, if you buy something, you get another one free. Like, you're convicted on the higher one, the other one is you're not sentenced on that one.
Right. You're not supposed to either be convicted or sentenced on it. But that's the old rule. That's the Richardson rule. But the Supreme Court just did away with that, and they adopted a different 2-prong approach that is difficult to explain, and mostly because I haven't read the whole opinion yet. But that's part of being a lawyer, man. I'll read that opinion when the issue comes up, and I know it's there. Shout out to DefendNet for continually talking about this opinion to the point where I thought, man, maybe I should go figure out what the hell they're talking about and read it. DefendNet is a listserv where people send out questions in Indiana about criminal defense issues. Anyway, I've been talking way too much. Please ask Kassi something.
Well, I can tell you that the new test explanation starts on page 17, because that's where I was like, oh, well, I'll just skip to the new test. And then if I can answer questions about what the new test is, then I'll seem smart.
Oh, can you?
Yeah,
Oh, well, I got there and then I got distracted by other things. I didn't read it, but I know where it is.
Because the next question is, does this new opinion provide more clarity than Richardson did?
Well, here's what I'll say about that. I was not a lawyer when Richardson was handed down, I don't think. So I have no idea how difficult it was to deal with these issues after Richardson. Subsequently, a bunch of appeals court opinions have clarified Richardson, and I think Supreme Court cases have clarified Richardson to the point where I had a pretty good understanding of it. Justice Goff seemed to take some exception with some judges on the Court of Appeals who didn't seem to have such a clear idea about what it was that it meant. He pointed out that sometimes they would confuse the two tests or use the same thing, use the same analysis for the two different tests, even though they're different, because one just requires looking at the statutes, the other requires looking at the facts. And I think it looks like the Indiana Supreme Court was just frustrated with people not being able to get it, not being able to understand it. And so they just wiped it away and created a new offense. I'm reading a lot between the lines. I could be wrong about that.
And this brings up, the point that we talked about before, which is that, we attorneys don't have all this stuff in the front of our mind at all the time. It's important that we, keep our pulse on, our finger on the pulse enough to know that this new case is out there. So when we have a case with an issue, we know we need to go look it up and do the research on it. And that's how being a competent practicing attorney works. You don't know everything all the time at the tip of your fingers in every practice area that you work in.
Right. Honest lawyer moment for a second, because, we haven't been being honest in this podcast today, admitting we didn't read stuff. But if you'd asked me like last week what Richardson v. State, I'd been like, yeah, it's got to do with sentencing and double jeopardy, I think. And that'd have been about all I'd have said about it.
Mm-hmm.
Obviously, I've been reading Wadle, trying to get up to speed on it, so I'm a little bit more competent. And I've certainly read Richardson before, but I've read hundreds of cases, if not thousands of them at this point. And my memory is good, but it's not that good. So sometimes you got to go back and read things. You got to go back and read things that you've read before, too, when you're a lawyer a lot. Just check and make sure you remember them right. Remember last week we were struggling to remember what the elements of resisting law enforcement are? I think together we figured it out. And it's a thing where if I had a question about it, I just go read the statute again. It's written down for a reason.
Well, it's also the facts of every situation. You get a lot of calls and they want to apply apples to apples to apples. And the facts of every single case is very important. And even if you've handled a situation repeatedly, may be treated differently under a new factual situation.
Now, we are going to cut to a short commercial break. And when we come back, we will bring you the latest Florida Man news.
Today's update on Florida Man is brought to you by 8.5 by 14-inch legal pads. When you need to let your opposing counsel know that you have more room on your legal pad to take 33% more notes, choose 8.5 by 14-inch legal pads.
One time, I walked into an office and the guy was packing 8.5 by 14-inch legal pads. I was like, oh, look at that legal pad. Can I touch it? I'd never seen a legal pad that big before, and I touched it until the guy accidentally spilled white out on my dress.
Please don't tell our daughter this is how we met. Also, this message is not brought to you by legal pads.
So Newsbreak 8 in Florida reports that Florida woman was busted after turning a bag of meth she bought into police because she thought it was junk.
This meth does not meet my discerning standards, officer.
That's exactly what she said when she turned her $20 worth of methamphetamine into the police because it was not up to her high standards.
And this is why they call it dope, kids.
Yes, and after confirming that the drugs were indeed meth, Florida woman was charged with possession of a controlled substance and later released from jail on a $2,000 bond.
Yeah, that'll happen. Unwise.
Very unwise. You don't take your drugs to the cops.
We originally created the Florida Man segment so that I could then say, and in Indiana, that is illegal under this law or that law.
Right.
But this is just like, yes, possession of meth is illegal everywhere.
Everywhere? What about Amsterdam?
Oh, okay. Everywhere in the United States.
Okay.
I don't know about Amsterdam. It's probably illegal there, too.
Probably. Now, the Daily Mail reports that Florida boy.
Florida Man, he prefers Florida Man in training.
Yeah, he's Florida man in training, 12 years old. He was arrested after taking 3 handguns to his private Christian school in his lunchbox and showing them off to his classmates.
Oh, that's just cool.
Oh, he thought he was cool.
He is cool. I don't know what you're talking about. He's a boy with 3 handguns. That's cool.
Yeah, Florida boy was arrested after bringing 3 handguns to school. He was led away from the Lighthouse Christian School and taken into custody. He was arrested after a teacher at the private school, which charges $8,200 for annual tuition, noticed how heavy his lunchbox was, and she decided to look in it.
Why was she carrying his lunchbox?
That's a good question. I'm not sure.
Keep your hands off my lunchbox, lunch lady.
Right?
That's weird.
Yeah, the teacher discovered 2 handguns and 2 boxes of ammo inside the lunchbox. And inside the lunchbox was a large revolver, a subcompact semi-automatic pistol, and 2 boxes of .38 caliber ammo.
For the revolver.
Yeah. A loaded semi-automatic gun was later found in the boy's possession as well. Mother of Florida boy told police that her son recently killed a family pet with a pellet gun.
Good job, Mom. Way to snitch the kid out away.
I know. Now, the boy's mother reportedly unlocked the gun safe from her uncle, but mistakenly left it unlocked, allowing the boy to access the weapons. In addition to the arrest, the incident was reported to the Department of Children and Family Services, and the boy was expelled from school. And that's all the time we have for the day.
Thanks, Terry. And thank you for listening to Tales from the Brown Desk. Please remember, while we may discuss legal issues and provide information regarding the law to our listeners, we do not intend to create an attorney-client relationship with any listener. Our advice may not be applicable to some legal issues. Please consult with an attorney you have hired to review your legal situation before you attempt to apply the things we have said to your case. Tales from the Brown Desk is produced by Rigney Law and edited by Terry Ulm. If you want to ask a listener question, email Terry at TERI@RigneyLawIndy.com and entitle your email podcast question, and we'll read it on our next podcast. Give us new content for free, you suckers! Buzzsprout says with this podcast, we'll get 24 downloads. 24, yeah, it's getting worse. That's weak as hell, yo.
Weren't we almost at 40 last week?
It goes up and down, but yeah, it's been bad, and it got worse. This doesn't make sense, because we had more downloads in September than any other 2 months combined in the history of this podcast. So I don't know how Buzzsprout's making that prediction, but I think they're wrong. I'm suspect. I don't buy it, Buzzsprout. I hope you hear me. I don't buy it. I mean, I do buy it. I buy hours from you every month to air this podcast, but I don't buy your suspect stats. Our last podcast only went live yesterday, so the farthest away new listener, is in Fishers, Indiana, one county over. Shout out to Paris, France, though. They are hanging in there with us still after all these months. The attorneys at Rigney Law do not comment on their current pending cases. Nothing we've said in this podcast is a comment on a case we are currently working on, even if your name is Chad, or if you just bought 100 8.5 by 14-inch legal pads. Take care.